Good evening, everyone. Welcome back, future lawyers, to day 19 of our bar review. We are now exactly 170 days away from the bar examination. Today, we are looking at the final general concepts of jurisdiction. How is it conferred, and how is it determined? Our guiding verse for today is Psalm chapter 75, verse 7. It is God who judges. He brings one down, he exalts one another. In the divine realm, God is the sole source of authority. In our judicial system, it is the law that acts as the ultimate source. As we learn today, neither the judge nor the lawyers nor the parties themselves can invent or manufacture jurisdiction. It must be granted from above. But before we tackle this principle, let us resolve the bar question I left you with back in day 16 regarding the distinction between an error of jurisdiction and an error of judgment. Here is the question we left hanging in day 16. The trial court admitted questionable evidence and rendered a decision dismissing the complaint. Attorney Cross filed a petition for certiorari under Rule 65 claiming the judge's poor appreciation of evidence amounted to grave abuse of discretion. Will the petition prosper? Let us reveal the suggested answer using Beer method. If you wrote this down, give yourself 4 points. First, the binary. No, the petition for certiorari will not prosper. Second, the enabling law. Jurisprudence provides that an error of judgment is one which the court commits in the valid exercise of its jurisdiction and is reviewable only by appeal, whereas an error of jurisdiction occurs when a court acts without or in excess of its authority, correctable by certiorari. Third, the evaluation. Here, the trial court already had jurisdiction over the person and the subject matter. The judge's act of admitting questionable documentary evidence and rendering a decision based upon it, even if legally or factually flawed, were mere errors of judgment committed in the exercise of that jurisdiction, not an error of jurisdiction. And finally, the resolution. Thus, the proper remedy is an ordinary appeal and the petition for certiorari will not prosper. To properly digest how jurisdiction is determined and conferred, we will use our 4-level analytical framework, the Bar Syllabus. First, the big picture, reinforcing the substantive nature of jurisdiction. Second, the essential pillar, where we tackle exactly who gives a court its power. Third, the elemental principle, where we uncover how the court figures out if a specific case falls under that given power. And finally, the root level, looking at a recent Supreme Court ruling applying these exact rules. For our big picture, we must never forget that jurisdiction over the subject matter is substantive. It is not a mere procedural technicality that can be brushed aside. Without it, any judgment rendered by a court is completely null and void. It is no judgment at all, and it creates no rights and no obligations. Moving down to our essential pillar. How does a court get its jurisdiction? Look at the image on your screen. Jurisdiction over subject matter is conferred only by law, meaning either the Constitution or a statute passed by the Congress. Notice how the golden beam comes only from the law. Look at the lawyers in the foreground. Their contract is turning into dust. This is because jurisdiction cannot be manufactured. It cannot be conferred by consent, agreement, or waiver of the parties. Even if both parties sign a contract swearing to file their case in a specific court, if the law does not give the court that court power, that agreement is absolutely void. Still in our essential pillar, we know the law confers jurisdiction. But how does a judge determine if your specific case falls under his court's power? The golden rule is this: jurisdiction is determined strictly by the allegations in your complaint. The judge will read your complaint, look at the ultimate facts you allege, and look at the reliefs you are asking for. If your allegation fit the jurisdiction granted by law, the court takes the case. Most importantly, jurisdiction is not determined by the defenses raised by the defendant in their answer or motion to dismiss. Jurisdiction depends entirely on the plaintiff's complaint. Now we reach the elemental principle. Are these rules absolute? In remedial law, there are always exceptions. Look at the visual on your screen, the chained hourglass. While jurisdiction generally cannot be waived, if you sleep on your rights for an unreasonable amount of time and actively participate in the trial hoping to win, the chains of estoppel by latches will lock you in. You can no longer raise the lack of jurisdiction if you lose. Second, while jurisdiction is determined by the allegations in the complaint, if the plaintiff cleverly phrases their complaint to hide the true nature of the case, but the real issues are blatantly evident from the records, the court will look beyond the words to determine its true jurisdiction. Continuing our elemental principle, when is jurisdiction determined? Jurisdiction is measured by the law in effect at the exact time the action is commenced, meaning the moment the complaint is filed and the docket fees are paid. As we learned in our previous session under the doctrine of adherence of jurisdiction, once the court validly assumes power based on the law at the time of filing, it retains that power all the way to the end, even if the Congress amends the jurisdictional amounts in the middle of the trial. Before we proceed to our root level, let us hit the pause button. Close your eyes for a brief moment. Actively recall the visuals and rules we just discussed. Can parties sign a contract to give a court subject matter jurisdiction? No, it is conferred only by law. What part of the pleading does the judge read to determine the jurisdiction? The allegations in the complaint. Finally, what does the chained hourglass represent? Correct. Estoppel by latches, the exception to non-waivability. Open your eyes. Excellent recall. Let us lock those concepts in. Let us bring this down to the root level. With the 2020 Supreme Court ruling in the years of Bastida versus years of Fernandez. In this case, the Supreme Court cemented the twin pillars we just learned. First, that jurisdiction over the subject matter is conferred strictly by the law in force at the time the action was filed. Second, that what determines the nature of the action are the allegations in the complaint and the reliefs sought. The court emphasized that if upon reading the complaint, the court realizes the law does not grant it power over those specific allegations, the judge is completely paralyzed. The only power the court has left is to dismiss the case outright for lack of jurisdiction. To wrap up our discussion today, here is a highly possible bar question testing the absolute boundaries of how jurisdiction is conferred. Let us read it. X Corporation sued Y Incorporated for an unpaid balance of 1,500,000 pesos before the RTC of Makati City. X Corporation relied on a contractual clause where both parties explicitly agreed to confer exclusive jurisdiction to the RTC. Y Incorporated filed a motion to dismiss, arguing that under the law, claims not exceeding 2 million pesos fall under the exclusive jurisdiction of the METC. X Corporation argued that Y Incorporated validly waived this and is bound by their contract. Should the RTC grant the motion to dismiss? I will leave this question with you as your assignment. Remember the golden beam of light from the Constitution and what happened to the lawyer's contract. Draft your best beer-style answer and we will reveal the suggested answer after 3 days. Before we officially end today's session, remember Psalm chapter 75 verse 7. It is God who judges. True authority always comes from a higher power. In remedial law, authority comes from the legislature. In our lives, our ultimate authority comes from the Lord. Thank you for joining me on day 19. Keep up the momentum and I will see you in our next session.